Hello, welcome. We're going to go and get started. Thank you guys for joining today, joining our Talk Tech webinar series. This is week 3 of a 5-week virtual mini-series on startup equity opportunities. This mini-series will help you learn about what investors are funding today, how to protect your IP, and some different equity funding options, and how to build a strong founding team, kind of the ingredients for your startup. Talk Tech webinar series is brought to you by the SBDC and UCI Beal Applied Innovation. The SBDC is funded in part by the U.S. Business Administration and the state of California's Governor's Office of Business and Economic Development, and of course, other sources and partners as well. The SBDC is here to help you start and grow and succeed in your business by providing you no-cost expert consulting and training such as this amazing webinar series that we're doing now. A little housekeeping before we begin. Everyone will be muted during the webinar. All the webinars will be recorded, and we will send them to all the attendees when it's concluded. Once the webinar concludes, you guys will get a survey. We'd ask you to take your time and provide us with some feedback. We want to know how we're doing, and we'd also like to know what other topics you'd like to hear. Tomorrow, the recorded webinar will be sent to all participants, and a PDF copy of the slides will also be included in the Dropbox link, which we will send to you. There will be a Q&A at the end of the presentation. Feel free to ask questions during the webinar on the Q&A box at the bottom of your screen. Once the presentation concludes, I will ask the questions presented in the Q&A box or the chat feature, depending on what you're seeing on your screen. I may not get to everyone's question, but I'll certainly do my best. And if we don't get to your question, please email it. We'll have an email address up there, but if you have a pen, I'll give it to you right now. It's KHALE D as in David, H @uci.edu. So send me your questions if we don't get to it, and we'll be sure to get you a response. Now this week, we're super excited. We have the pleasure of hearing from Bryant Lee. Bryant provides tailored, high-touch assistance to venture-backed companies to strategically plan and develop IP portfolios, intellectual property portfolios. I'll give you that email address one more time, just stand by. As co-founder of Cognition IP, Bryant brings his executive experience to his strategies for IP development, and he helps startups effectively use IP in the context of their overall business. He'll be talking you through identifying IP. He'll give you an overview of what, where, and why you need to protect it. He'll also speak specifically about IP strategy and how you keep it safe. Let me give you that email again one more time. It's KHALEDH@uci.edu. And again, that link will be provided, or that email address will be provided at the very end of this presentation. So that's it. We're going to go get started. Thank you for speaking today, Bryant. I'm going to turn it over to you.
Wonderful. Thank you so much for inviting me to give this presentation. So very honored to be here talking to you for the SBDC series that you guys have put together. So today's talk, I'm going to be covering making IP part of your startup strategy and also 5 ways to keep your IP safe. So let's go ahead and jump into it. Just as a quick introduction about me, so I'm the founder and CEO of Cognition IP. I am an IP lawyer. I formerly was at a law firm called Covington & Burling, working in Washington, D.C. Covington & Burling is one of the largest law firms in D.C. They have many very skilled lawyers. So the former Attorney General Eric Holder is one of their partners. And when I was there, I was representing a lot of large companies like Hewlett-Packard, Texas Instruments, Purdue Pharmaceuticals, and AstraZeneca, and many of their IP matters, including a lot of large litigations in the hundreds of millions of dollars. Before that, I was graduated from Harvard Law School, and I was also I had a technical background as a PhD candidate in computer science at Carnegie Mellon. In terms of a little background about Cognition IP, so we are an IP law firm for startups, and we specialize in providing IP strategy for early stage companies. We use modern technology to streamline processes and produce the highest quality results, and work in a more efficient way than other traditional law firms that don't use technology. We're also a startup ourselves in developing our own technology. We're backed by Y Combinator, Khosla Ventures, Mayfield Fund, and Basis at Ventures. And so we have that experience not only of IP, but also building a startup business in the Valley. And we've helped over 150 startups with their intellectual property since we've started this firm. As a summary of what we're going to be talking about today, the first topic we'll cover is identifying IP, what you need to protect and why. We'll then cover IP strategy, choosing counsel, having your plan and budget, and filing. Lastly, we'll cover keeping your IP safe and some 5 quick topics on IP ownership, NDAs, confidentiality and your employees, security, and protecting yourself against trolls. Let's cover the first topic, identifying IP, what you need to protect and why. As an initial matter, let's talk about what is IP, first of all. Intellectual property is any product of the human intellect that the law protects from unauthorized use by others. There are 4 different types of IP that are recognized by the law. One is trademark, the second is copyright, third, trade secret, and fourth, patent. Let's talk about each of these in turn. First, a trademark is a word, phrase, symbol, or design that distinguishes the source of goods of one party from another. So the idea is that by looking at a trademark, someone would be able to determine the company or entity that is producing that product, and therefore they would have an understanding of the quality you would expect. So if you look at a logo for Disney, you have a different sense of what the company is about or what produces versus Tesla. So a trademark protects your rights to your brand name, slogan, and logo. So there are various ways to protect a trademark. The strongest protection you can obtain is by applying for a federal trademark registration. That's a federal trademark that will be granted by the government after an examination process. There's also what's called common law trademark rights, which we can talk about later, but those are much weaker. In terms of how long a trademark lasts, that length of time can be potentially unlimited. It can last forever, as long as you're still using the trademark. Copyright is protection for original works of authorship that are fixed in a tangible form. What's important to know about copyright is it prevents against copying of expression, but does not prevent the copying of ideas. So copyright is very important for media companies particularly. So books, movies, music, video games, and artwork, these are all very important things that are protected by copyright. And when we talk about copyright protecting expression but not ideas, that means that you could not copy the latest Avengers movie. You couldn't rip that and share it on the internet because that would be a copyright infringement. But the ideas underlying it, the underlying ideas about the plot and that sort of thing is not copyrightable to the extent that it's not a specific expression. So you could make another superhero movie that included, 5 superheroes, but you can't copy the entire movie. Now, even if you're not a media company, there are ways that copyright can help you. So many companies will be online and have an online presence. And so copyright will protect things like your website, blog posts, online videos, and social posts. The duration of copyright is the life of the author plus 70 years. Or for work for hire or anonymous works, the copyright will last for 95 years after publication or 120 years after creation. Trade secret is secret information that has business value. So trade secret includes confidential business and technical information, source code, secret formulas, technical specifications, business plans. The requirements for trade secret is that it is actually a secret and that you take reasonable efforts to preserve secrecy. So that means you can't go out and tell other people about it. You would need to have reasonable security measures for your business to make sure that other people can't steal it. And once you do that, then you would have what's called a trade secret. Trade secret protects you against misappropriation by others. That means that if you have a trade secret and someone was to break into your office and steal your secret formula, you would have rights against them under the law. So they're not allowed to do that. That's a misappropriation of your trade secret. Likewise, even if you tell somebody about it, but you have what's called an NDA, a non-disclosure agreement, meaning that you've signed a contract with them, making them promise not to tell other people about your secret, you can enforce that not only as a breach of contract, but also as a trade secret in itself, as your IP. So the duration of trade secret is potentially unlimited. So famous examples of trade secret are, for example, the formula for Coca-Cola. That's a trade secret. and that has existed for almost 100 years. And they don't have like a patent or anything. They just keep it secret and in like a very secure location in a vault, and they don't let anybody know what it is. And that's what's called a trade secret. Lastly, we have patent. So patent is the exclusive right to make, use, sell, or offer to sell an invention. To obtain a patent, it requires inventing something that is both new and not obvious. So you can't patent something that already exists or that someone else has already created or written about. In order to obtain a patent, you would be applying to the US Patent and Trademark Office, and it would go through an examination process until that patent is allowed. And patents can be obtained for all kinds of technology, including software, hardware, biotech, as well as things like consumer goods, computer devices, all sorts of things. And the duration of patent is that it lasts for 20 years after the filing of your patent application. Now that we've talked about the type of IP that exists, let's also talk about the things in your business that you would want to protect. So first, almost every business is going to want to protect their brand. So if you have a company, you're going to want to file for a federal trademark on your brand name as soon as possible. As I mentioned before, through use of your brand, even if you don't file for a trademark, you do have what's called a common law right by default, just through use. But those rights are limited to the geographic area that you used it in. And it's a lot less powerful than if you had federal trademark registration, which once you file for and obtain the federal trademark, it gives you rights across the entire country of the United States. So for example, if you had a taco truck in Oakland, California, and you called it Oakland Tacos, that name would only have rights in Oakland, California. You wouldn't have rights in Sacramento, California, or Los Angeles. But if you filed a federal trademark for Oakland Tacos, that would have nationwide rights, and you would have exclusive use of that name across the country. So federal trademark registration is cheap and easy, so that's why it makes sense to do this for almost every business. And the US Patent and Trademark Office will examine the application for trademark over about 6 to 8 months. So why is this important? Why would you want to file for a trademark? So one of the main problems is if you don't file for a trademark, competitors could easily steal your name. One famous example was that the Autodesk founders originally had named their company something else. They had another name they actually liked better, but they didn't file for the federal trademark registration. And so they spent several weeks or months talking to people, going out to meetups, going to startup pitch events, talking to investors, all with this name that they hadn't trademarked. So it turned out that one of the people that had heard about this name ended up thinking that it was a really good name, so they ended up filing the trademark application first. And so someone else got that trademark, and they had to use this other name, Autodesk, which was actually their second choice. Another second reason why you would want to file for a trademark is that branding can be very expensive. And so before you go out and spend money on your marketing and branding, you would want to make sure that you have the brand and can get that brand name exclusively, and no one else is going to take it. So that's why for trademarks, you would almost always want to do a trademark search first to determine that name is available and no one else has obtained it before you file a trademark, as well as also before doing any expensive branding or marketing exercises. So the next thing you'd want to protect is your product. It's very important to make sure that you own the IP underlying your company. So that means that all the co-founders of the company will need to assign their IP to the company. So by assign, that means to transfer the rights of that IP to the company so that the company owns it and not the individual person. So the reason that's important is because if one of the co-founders or anyone else was to own the IP, they could stop the company from being able to produce the product and basically shut the company down. Likewise, you'd want to have all your employees and contractors sign IP agreements that sign all their work product to the company. And in addition, you're going to want to require your third parties to sign NDAs before sharing any important or confidential information with them. The purpose of the NDA is to make sure that it's a contractual agreement that they're not going to tell anybody else about your idea, which is important to preserve your trade secret rights. So, before sharing any confidential information, you're going to need to have an NDA signed. So what are the issues consequences if you were to not protect the IP on your product? If you don't own the IP, then the company is pretty much sunk because you wouldn't be able to practice the services or product that you had created. So one of the common issues that comes up is with co-founders. So sometimes when people are just starting a business, and obviously if things are very early, sometimes there's a lack of formality, and people don't necessarily have all the co-founders assign all of the IP to the company in a formal written document. So that can lead to a lot of issues if one of the co-founders later leaves the company and says that, oh, actually I own the IP and the company doesn't. So one famous example was Facebook. If any of you have seen the movie The Social Network, for example, that movie was actually about an IP matter. So the movie itself was about, well, the creation of Facebook by Mark Zuckerberg. He had originally worked with the Winklevoss twins, two twins who were at Harvard, on their social network product. But he then left to form Facebook. And so there was a disagreement about who owned the IP and the idea about a social network. And that led to a $65 million settlement that Facebook ended up paying to the Winklevoss twins. Similar situation happened with another social network called Snapchat more recently. So Snapchat had three co-founders, Evan Spiegel, Bobby Murphy, and Reggie Brown. So Reggie Brown ended up leaving the company pretty early, but then he later sued the company because he alleged that he had actually come up with the idea for disappearing messages, and that Evan Spiegel and Bobby Murphy were the ones that were just using the idea, but he had come up with it. So through the various arguments about the ambiguity of the IP assignment and ownership, Reggie Brown was able to go to court and then require Snapchat to pay him a settlement. So he received $158 million and also a formal acknowledgement from Snapchat that he was the one who had come up with the initial concept. So the third thing that you would want to protect as a business is your innovations. Innovations, I mean any R&D and new technology you've developed. So to protect your innovations, you're going to want to file patent applications on those innovative technologies. Patent protection will grant you a monopoly on the technology for 20 years from filing. And this allows you to profit from making investments in R&D. The idea is that the federal government created the patent system because they want to incentivize people to create. And they know that if there's no patent protection and you create an interesting idea, if someone else was to copy it, then that would drive down the prices and there'd be too much competition and people wouldn't want to invent things. So that's a government granted protection for products that are actually innovative and usually hard to develop, but are easy to copy. So patent law actually comes from the Constitution, where in the Constitution itself, it talks about granting Congress the right to grant patents to promote the advance of the arts and sciences. And so that's really the purpose of patents. Turning to the next slide, what are some examples of things that are patented? One, pharmaceuticals. So drug makers rely very heavily on on patents because they make their entire profit on their drugs during the period of patent exclusivity. After the exclusivity is over, generic drugs can enter the market and they take a lot of the market share and reduce the prices very significantly, sometimes by 100 times the original price. And so that really reduces the profit. So that's why they need patents in order to make it worthwhile to do the R&D necessary for drug development. Second of all, consumer goods are often also patented. So successful consumer goods companies are going to need to have patent protection. So because that's also something that's easy for companies to knock off. You could have a lot of foreign companies coming to the market with cheap copycats that would drive down prices and not allow the innovator to make any money. One example is if anybody has seen the show Shark Tank. So Shark Tank is a show where there's several investors that are looking at a product and they're going to decide whether to invest or not. So on that show on TV, they look at a lot of consumer goods, and one of the common questions they ask is whether there's a patent, because they know that if the company doesn't have a patent and they go to market, someone else can easily copy it and they won't be able to recoup the investment. Another area where patents are often used is hardware products. So hardware also requires a lot of R&D, but they're also easy to reverse engineer and copy. So once Apple launched the iPhone, that's something that's easy for other people to take apart and create other smartphones that are copies. So that's why patents are critical to protect the form factor and the way it works. Lastly, software. So software patents are still valuable today. There's been quite a lot of news about software patents in the media, and there have been some articles saying that software patents are less valuable now after various changes in the law that have occurred. So while there have been changes so that software patents aren't necessarily as strong as they once were, they still are very common. 50% of the patents filed in the United States are on software-related inventions, which is surprising to many people. But software is still alive and kicking in terms of patent law, and it is used quite often to protect valuable technological innovations. The top patent filers today are, number one is IBM. Also in the top 10 or so is companies like Samsung and Google. And so it's definitely very common to protect software with patents. On the next slide, I just have some examples of things that are patented or that were patented in the past. So the original Super Soaker was patented. That's why there were no other copycat products that looked exactly like that. And if you wanted Super Soaker, you had to buy the real Super Soaker. Various drugs like Claritin, the drug with that active ingredient was patented. And it's now off patent, which means now you have copycat products that are generics that offer the exact same thing. But before the patent expired, you could only get Claritin by buying it from the branded Claritin. Lastly, on the right, this is an example of the iPhone patent, or one of the many patents covering iPhone. So this is on the form factor and the way the iPhone looked, with the rounded corners and the minimal front style with one button. So that's why other devices couldn't look the same way. So even though Google launched other phones, they couldn't have the same look as the iPhone. Let's talk about timing. So when do you want to file a patent? So it's important to file early to obtain a favorable priority date for your patent. So the United States and all major countries grant patent rights using what's called the first to file system. That means that the first person to file for the patent is the one who obtains the rights to that patent. So even if you were the first to invent the invention, if someone else invents it after you but files the patent before you, then they would own the patent. So that's why it's important to be the first to file. Second of all, there's actually specific time limits that limit when you can file for a patent. In the United States, you need to file the patent within 1 year of your first public disclosure of the invention. So public disclosure includes things like a product release. If you wait more than 1 year after you release the product to the public, then you usually cannot patent that anymore. Similarly, other countries are even more strict, and they require filing the patent application before there's been any public disclosure. So in other countries, like all the European Union countries, or Canada or Japan, for example, if you were to publicly disclose your invention by telling anybody or publishing a scientific paper, once that occurs, you cannot file a patent application anymore. This also explains why it's important to use NDAs, because if you use an NDA, that doesn't count as a public disclosure and will allow you to still be able to file your patent. And the things to watch out for example, that are public disclosures are product releases, conversations with investors, which are usually not under an NDA, and also scientific publications. So all of those things would trigger the 1 year in the United States and also could potentially prevent you from being able to obtain patent rights in other countries. A lot of people have also heard of what's called a provisional patent application. So I want to make sure to cover that. The provisional patent application, it allows you to obtain an early priority date for your patent. A provisional patent application is faster and quicker to file than the regular non-provisional patent application. So this allows you to meet those deadlines more quickly. The invention doesn't have to be fully complete. And once you file the provisional, you have 1 year to perfect the invention and file the regular application. Provisionals are very helpful for early stage companies because they're easier and less resource intensive to create and lets the startup get something on file. And so they're not scooped by somebody else. This is the general flow of the patent application process. So in general, the patent examination process takes about 3 to 4 years to complete, which can be a long time for startups to go through. But there is a way to speed up that process by using what's called expedited examination under Track 1 in the United States Patent Office. If you use the expedited examination process, the US Patent Office will review and examine your application within 1 year. So that does speed up the process if you would like. Now going through this chart, you could file a provisional application, which is common for startups to use. It's optional. You then have 1 year to file the non-provisional application. Once you file the non-provisional application, the US Patent Office will assign a particular examiner, which will go through the process and examine your application. The examiner has 2 options. He can either reject your application or he can allow it. If he allows it, it becomes a patent. If it's rejected, you have the chance to amend the application and make arguments about why your invention is patentable. After you amend it, the examination process continues, and the same thing occurs. The examiner has two options to either reject the amended application or allow it. And that process will continue. After each rejection, you have the opportunity to amend. The process will continue until either the application is allowed or you decide to abandon or give up on the application. Great, so let's turn to the next section. So IP strategy, choosing counsel, determining your plan and budget, and filing. As we discussed, IP is at the heart of your business value. The different types of IP can be mapped to the different parts of your business in the following ways. So trademark covers your brand and protects your business goodwill. Copyright covers content and is really helpful for media companies. Patent covers your inventions and is critical for R&D heavy companies. Trade secret covers the know-how and general business knowledge that you've developed in your company. When you're thinking about choosing counsel, the first thing to know is that there are specialists in each type of IP. So there are lawyers who would do trademark, and then different lawyers who do copyright, and different lawyers for patent, and so forth. And also, these lawyers are going to be different from your general corporate counsel. So the corporate counsel you would use to form a company or to do fundraising or investment or issue stock options is going to be a different lawyer than you would use for different types of IP. The different ways that IP counsel can help you are, first of all, with counseling. So counseling is with helping you determine the overall strategy with your IP, determining what to do next to either pursue your own IP or defend against others' IP. Second, IP portfolio development. So IP portfolio development means doing those filings we talked about for trademark and patent to develop a portfolio of IP that's owned by your business. And third, enforcement. So enforcement is enforcement meaning that filing lawsuits or like sending cease and desist letters to other companies to pursue your IP rights. And also on the flip side, to defend against cease and desist letters and lawsuits launched by other companies. So I would recommend finding IP counsel that works both with your company size and industry. So there are like law firms and lawyers divide themselves up and segment into different types of companies, particularly by the size of the company. So there's many lawyers at large firms that would work with large companies like Google or Samsung. And so they would be familiar with those types of issues, but they wouldn't be familiar with the issues faced by startups related to like, developing IP on a more constrained budget or working with co-founders, making sure you have the IP necessary for investment and so forth. And so you'd want to find IP counsel that's familiar with, for example, startups if you're a startup, or SMB if you're an SMB. Similarly, you would want to find IP counsel that is familiar with the industry you're in. IP can be dependent on industry, particularly if it's patent, for example, based on the technology. And so you'd want to find IP counsel that is familiar with the type of industry you're in, whether that's, for example, more of a retail business or a software business or hardware, for example. So let's talk about a general type of IP plan you'd have as a startup company. As a startup, you'd first want to make sure to use the correct employment and contract agreements to ensure IP ownership. This is probably the most critical thing at the early stage of your company when you're incorporating and setting up your company. You'd also want to make sure to use NDAs to ensure your trade secret protection. You don't lose trade secret protection by not using your NDAs. Third, you'll want to trademark your brand name. That's useful for pretty much every company out there to get the trademark. Fourth, make sure you file provisional patent applications if you're doing key R&D. And fifth, make sure to register copyrights if media is a key part of your business. In terms of a budget, for a startup, you could get all of this done for about low 4 figures. And if you have a need for patents, though, patents are a bit more expensive because you have to have a lawyer to write a pretty extensive patent application. So that could be more of a mid to high 4 figures to do patents if you need to do those. So talking about the filing process, typically you'd probably be working with an IP lawyer who would do the filing for you. But if you were to do the filing yourself, these are the places where you do the filing. So for trademark applications, you typically do a trademark search first before you do any filing. But then you'd go to the Patent and Trademark Office to do that through what's called TEAS Online, which is the online filing system. For patent applications, you'd also go to the US Patent and Trademark Office using what's called EFS Web. And with copyright registration, you'd go to the US Copyright Office using what's called the ECO online system. Now, in terms of developing IP strategy, it's good to have a process for this so that you make sure that you're protecting what's most important to the business. So the way that I like to do it is to develop an invention catalog. So every time you develop something important in your business, I would suggest creating a spreadsheet for that and then putting the different inventions in the spreadsheet. And then you can rank them based on like how important they are according to certain criteria. One of them being how core the invention is to your business, whether it's used in your product, whether the technology is more of an evolution or revolution in technology. And through all that, you can calculate what's the most important and less important inventions in your business and file patents on them, or decide to use some of them as trade secrets instead. It's also valuable to think about your company using an IP mind map. This is another technique that's useful for IP development. So an IP mind map is thinking about all the different parts of your product and the different areas that you could have IP in. So if you're developing a software application, you can sort of split it up into different things. You could have patents on the interface, you'd have technology on the backend processing, on the hardware. And so you'd want to think about what IP you could protect in each of these areas. One of the tips that I have is to look at competitor companies in your space that are maybe a few years ahead of you and look at what patents they've filed, and then you could see what areas that they've covered. What's the variety of different places they've looked for IP? And you could use that to build your own IP mind map for your own company. So also, when you develop your company, you're going to have needs for ongoing IP collection. So as you develop your business, you have other employees working there, and so you're going to need to get all of the information from them and go through, have a formal process for creating IP. So this sort of maps out what that would look like. In this case, you would have, for example, the engineers or scientists working on your technology, and you would have them fill out what's called an invention disclosure form. An invention disclosure form is a very simple form, usually a couple pages long, that basically asks people what the invention is that they've created and how it compares to what existed before. With that information, you would have an invention review process. So most companies have this as an internal review process with several executives and maybe some people on the technical staff to review the invention disclosure forms that come in and decide which ones to prioritize to pursue for patent protection or trade secrets. After the invention review process and deciding which ones to pursue, you could work with your IP lawyer on the ones you've selected for patenting, in which case you'd have what's called an invention disclosure meeting. In the invention disclosure meeting, the person who invented the invention will talk with the lawyer for about an hour to go over the invention and just explain what it is so that the lawyer understands the technology. From there, the lawyer can prepare and file your patent applications. On the other hand, for different technologies you've selected to not pursue for patenting, that's something you want to keep record of as future potential IP. And that's something that would potentially be a trade secret for you and something you could decide to pursue as a patent later. Now, one of the situations that comes up frequently for startups is what to do when they're talking to investors and how does that impact your IP. Now, when you're going to investors, the checklist they're going to have for the business is going to include various items for IP as well as other things. So they're also going to be looking at other things like probably your growth and revenue, your founding team, and so forth. But they'll also have various items they're going to look at for IP. And so here's the checklist of things that commonly come up with investors. So first, they're going to want to know and have assurance that the company owns all the IP. This is what we talked about with all the correct IP assignment agreements. If there's any issues with that, that's a major red flag for them, and that could really significantly, severely, negatively impact your ability to obtain investment. Second of all, they'll want to know, or at least see, that you've taken steps to trademark the name. So this is not as maybe as completely necessary because sometimes you can get by without a trademark, but it does create a lot of risk as a red flag for the investor that if someone else was to file for the trademark, you might have to go through an expensive rebranding process and lose all the business goodwill. So that's a significant risk for investment as well if the startup doesn't own the trademark. Third, if you're an R&D type of business and you have technology you're developing, you'll want to have provisional patent applications filed on the technology. So if you haven't filed the patent applications yet, then that creates a risk for the investor that someone else could file it first and get the IP first. Also, it could create risks for them because if you pass those deadlines we talked about, the 1-year deadline in the US after product release, you might end up in a situation where you are never able to get the patent. And so if it's a business that relies on the technology, that could also really destroy the value of the company. And that's why that's also a risk for the investors. Fourth, they'll also want to have a sense that you have some IP strategy you've developed. So having a sense of how you're going to approach IP and how to develop an idea about what you're going to protect in different ways. Fifth, in certain industries, it's also important to make sure you have freedom to operate. So freedom to operate is the flip side of IP, which is whether you're infringing on the IP rights of anybody else. So the investors, if you're entering into a new market, they're going to want to know that you're going to be able to go to market without being sued, particularly in areas like life sciences, medical devices, and so forth, or hardware. And so they'll want to make sure that you have freedom to operate and have checked that you've worked with your IP counsel to do what's called a patent search to see what other patents are out there and have evaluated those patents to make sure you're not infringing on anything else. Now, aside from these considerations, it's also important to know that most investors won't sign an NDA. So that means if they haven't signed an NDA, then when you tell them things, that's what's considered to be a public disclosure under the law of both patents and trade secrets. So that means that you don't want to disclose anything that's very secret, particularly no secret sauce in your business, and don't disclose anything that is going to be a trade secret or something that you want to patent. So, many startups ask us, how do you go about talking to investors then if you can't disclose some of these ways your business works? So my recommendation is to really talk with investors about the kinds of results you've obtained with your technology and really impress them with that. And then maybe talk at a conceptual level about what you're doing and something at a level at which you don't mind people knowing, but not going into any more detail than that. So talking about the last topic here, keeping your IP safe. So we're going to go through some quick tips here about going through various items here. One being IP ownership, 2, NDAs, 3rd, confidentiality and your employees, 4th, security, and 5th, protection against trolls. IP ownership, as we discussed, the creator of a work will by default own the IP on that. So that means the inventor of an invention owns the IP on the invention. Someone who wrote a book will own the book. So that means that you need to have a contractual agreement in your employment agreements and contract agreements where those individuals who are creating technology or work for your company are automatically assigning those works to your company. So you'd want to work with a lawyer to create this. This is very important. The lawyer should have a template available that they can give you to use that has the right language. One thing to look out for is that there needs to be what's called a present assignment and not a promise of future assignment. So the contract would need to say something like, I hereby assign all of my IP rights, which would be a present assignment, meaning that right now I'm assigning it, but not something that says like, I promise that I will assign the IP of my work. That isn't sufficient. That's a major problem that has come up in the past because a future assignment is not actually an assignment. It's a promise to assign, but it's not the assignment itself. So you'd want to make sure you have these agreements signed as soon as possible before you start work. Number 2, let's talk about NDAs. So an NDA is an agreement to keep information confidential and not use it for other purposes. This is something you'd use, for example, if talking to other potential partners. Also, if you're talking to potential companies you would acquire or be acquired by. And these NDAs are important because it's required to use an NDA when you're sharing confidential information if you want to preserve that information as a trade secret. If you share information that's without having an NDA, that's considered a public disclosure. The person who receives it is not under any obligation to not either use it for themselves in their own business or to tell other people about it. When you're doing NDAs, make sure you read the NDA and ensure you're fully covered. Make sure, for example, there's no time limits on the NDA and no exceptions that would render your information to not be confidential. Going into a bit more detail, there are very common patterns that come up in certain NDAs. So some NDAs will state that the confidential information has to be marked. That, some NDAs will say that the document has to be marked confidential on it in order to be covered under the NDA. If you're dealing with an NDA that says that, you need to make sure that you mark your documents as confidential. Other NDAs will say things that they'll have certain procedures for information to be covered, like you have to send the other company a notice or email to let them know the information was confidential, in which case you'd want to make sure to do that. Also, you need to make sure that the NDA doesn't have what's called a residuals clause. So residuals clause is something that's tricky that sometimes other companies will put in. You need to make sure that are not in your agreement. Residuals clause states that the other company can't use any of the confidential documents you give them, but they can use any memories they have that are in their unaided memory. So if they remember anything you tell them about, that information is not under the NDA. And so if you have a residuals clause, that is not sufficient to protect your trade secrets, and means that you would not have trade secret protection if information is disclosed under those conditions. So you need to make sure there's no clause like that in your agreements. Third, it would be important to make sure your NDA isn't term limited. This has come up in certain cases where if the NDA says that the other party only has to maintain the information confidentially for a certain amount of time, usually several years, after the time limit is up, all that information becomes non-confidential. And so you need to make sure that there's no time limit on the amount of time the other company needs to have to maintain the information secretly. Third topic, let's talk about confidentiality in your employees. So your employment agreement should have a confidential information provision where the employees agree to keep all the information confidential. This is also important for trade secret protection. And the employees should not be allowed to share the information outside of work. Also, you would generally have provisions requiring the return or destruction of information when the employee separates from the company. Fourth, talking about security, so you should have an employee handbook with policies about your confidentiality and sharing. Make sure your business location has physical security, like locked doors and filing cabinets and access control to the building, and also controlled visitor access. The physical security can also affect trade secret protection. So if you didn't have any security and people were just walking in and out, maybe on tours of your business, and they could access any files and could see your whiteboards, that will also destroy trade secret protection. So you need to make sure you have physical security as well. You would also want to make sure you have secured computers and network. And ideally, you would have company control over your computer devices where you can monitor downloads and physical transfers over USB. So one of the most common ways that trade secret comes up is if departing employees try to take information with them, because a lot of companies have really valuable technology, and employees who are leaving, it just comes up over and over again where there are cases where some employees have tried to take technology with them to their next company. Famous example was Waymo v. Uber, a very famous trade secrets case in the news recently, where one of their very high up engineers downloaded 13,000 documents about their self-driving technology at Waymo, which is a subsidiary of Google, and took that information with him to Uber. And the reason why Waymo was able to detect that is because they were monitoring his computer, and they could detect when he transferred the data to the USB. So you want to make sure to detect not just your network transfers over email, for example, because employees will sometimes, it's come up in cases where employees have tried to email themselves secret information, but you'd also want to detect transfers over USB, because that is also another way that has come up in the past. Lastly, you want to have your employees sign a document that verifies that they're not taking any confidential data with them when they leave. So when they leave, there's actually a document you can have them sign that has them verify that. The fifth topic, let's talk about protecting yourself against trolls. So a patent troll, when people talk about trolls, they mean a patent troll usually. A troll is a company that does not produce anything or run a business other than suing companies based on patents. These patent trolls can be very burdensome and expensive to deal with. They would often sue a lot of companies based on old and very broadly written patents. So even though you feel like you're not using anybody else's technology, there are some old patents out there that are worded very generally. And so sometimes these companies can argue that these patents cover a very broad swath of things. So if you end up in a situation where you're dealing with a troll, I would recommend you talk with patent counsel to review the claims and determine what response is needed. Sometimes they'll send you a demand letter first, and so you'd want to develop a response to the demand letter. And if you end up in a situation where the other company the troll has filed a lawsuit, you will be under, there is an obligation to respond to the lawsuit within a certain period of time, which is very fast. And so you're going to want to make sure you talk to lawyers very quickly if you're in that situation. So let's talk about how to avoid and deal with lawsuits. First thing you can do is to perform freedom to operate searches to ensure you're not infringing on anyone else's IP. So by doing a freedom to operate search, you can actually sort of avoid those issues to begin with by making sure your product doesn't use anybody else's IP. Also, the best defense is really good offense. So if you're in a situation where competitors have a lot of patents and they might sue you for patent infringement, the best defense is really to develop your own patent portfolio. Because then if they sue you, you can launch a countersuit, and that really deters them from trying to stop you with their own patents. Lastly, there are powerful new ways to respond to patent lawsuits since what's called the America Invents Act, which is a statute passed in 2013. One being what's called inter partes review, which is a new procedure at the Patent Office, which allows you to knock out patents more easily. It allows you to invalidate existing patents that have already been granted in a way that's a lot more efficient and cost-effective than the way you would have to do it in court. Also, there is a recent case called Alice, which you may have heard of in the news, which invalidates some software patents. And so if you face that situation, that can also be an effective response. Alice is really, it's more aimed at, for example, business method and financial patents. So as I mentioned before, a lot of software patents are valid, the majority are, but there is a good number on more of a business method, very broad business method and financial technology that can be invalidated with the Alice case. So turning to a recap, let's talk about how IP fits into your startup strategy. So we talked about how IP is a critical component of your business. It's important to protect your brand with a federal trademark. Another important factor is to ensure you have IP ownership with proper IP agreements, and you use NDAs to preserve IP value. And lastly, we would recommend patenting your innovations to keep out competitors in the marketplace. So thank you very much for your attention. And right now I'd love to answer any questions that are out there.
Bryant, actually, thank you so much. There are a number of questions, and let me jump right into them. First of all, can you speak to, from a budgeting perspective, some of these companies were wondering, what is the expected cost of, let's say, a patent search? And then what would be the cost if you were trying to get a freedom freedom to operate, freedom to operate on their patent?
Great question. So a patent search can usually be done for about $1,000, and that it's very extensive because the person doing the search would need to search patents in the United States and worldwide. There's quite a large number of them. There's 10 million patents issued in the United States. There's millions of patents in the world. And then if you wanted to have a lawyer produce what's called a freedom to operate opinion, which is a written document that gives you assurances you could show to investors that you do have freedom to operate, that's another couple $1,000s on top of that. So the search itself is probably about $1,000, and then the opinion on top of that, if you needed it, is around a few $1,000s.
Okay, that's great. And then we had a question: who signs the invention disclosure form, and should it be assigned to company IP?
So the invention disclosure form is a pretty informal document. So you don't necessarily need to have someone sign off on it, but you do have someone submit it, and that's usually the inventor. So the inventor would fill it out, and they'll put their name at the bottom so that there's a document of like who created it and who to contact for it. And that invention disclosure document is a company document, so it would be owned by the company, assuming you have all the proper agreements in place in your employment agreement.
Okay, thank you. And then we had you were talking a little bit about, when employees separate from companies, and you obviously want to make sure that you have policies in place to protect confidential information. But when an employee separates and they start going after your customers, how would you try to control that proactively prior to a separation?
Yeah, that's a great question. So there are agreements you can, that's related to IP as well. So that's somewhat different from trade secrets, but there are agreements you can make and should be in your employment agreement, which says that what's called an anti-solicitation clause, where they can't solicit your customers. That can be effective for a certain period of time after they've left the company. You can also have what's called a non-compete. So non-compete isn't effective in California, but if you are outside of California, then you could have a non-compete, and that would prevent them from working at another company or starting their own business that would compete with yours for a limited period of time, usually 1 year.
Sure. Just kind of a follow-up on that. On the non-solicitation, those are enforceable in California. And typically, what period of time do you see those like traditionally being created, structured?
Yeah, the anti-solicitation is usually about a year in the sort of standard documents.
Okay. And then just follow up on the cost questions. We talked about freedom to operate. We talked about doing a patent search. And then roughly, can you just kind of speak to the cost of a patent? I understand it's going to vary depending on the complexity of the patent, but can you give us a ballpark of what that would look like?
Definitely. So patent applications, it would depend based on the technology area and how extensive it is, how developed the invention is. But it will range from a few thousand, mid four figures, so in the thousands.
Okay. And let's see, I've got inter parties review is a double-edged sword where a big company can copy an invention with deep pockets, good lawyers can invalidate a startup patent. Can you speak to that?
That's true. So inter parties review can be used by any company. And so if you own a patent, it's also a danger for your own patents because a large company can try to use inter parties review to invalidate your patent. So the ways you would sort of protect against that is make sure you invest the time and work with a good lawyer to try to protect your patent as much as possible.
Okay, thanks for that. I think that answers that question. And then when you're talking about the medical device or med tech space, how frequently do you see trade secrets being used because they don't want to file the patent and reveal all of their secrets? How often do you see trade secrets actually being used effectively?
So with medical devices, trade secrets could be effective if there's back-end processing. So if there's something that's not in the device itself that's maybe sent to a server and data you're using, that's something where you can use trade secrets. In the device itself, you generally wouldn't use trade secrets because that's something that's put on the market. And so a competitor could just buy a copy of that and reverse engineer it. So that, you could use trade secrets, but more on the back-end processing or like data collection and processing part of it.
Okay. And then, Bryant, if you have assigned a patent to the company properly, and that company ends up going out of business, is there any way for the original creator of that patent to get that IP back, or does it just die with the company? How does that work exactly?
Yeah, so that's a great question. So that's a situation that comes up with a lot of startups. The patent is owned by the company, so that means when it goes through bankruptcy or whatever means they use to shut down the company, that asset will be distributed in some way. So sometimes they might sell it on the market to get money they would give out to the investors. Otherwise, in that situation, I guess if you were the inventor, I would suggest reaching out to the company and seeing if you can buy it back from the company. And it's a distressed asset, so potentially you could buy it at a very low price.
Okay, and then just one last question here related to sharing of information prior to filing your patents. If you are working with consultants and you are sharing information about your invention, our presumption is based on what you've been talking about, that is protected, that's confidential, and that's a protected conversation. So
for example, if you've hired consultants, then you would want to sign an agreement with them. So the same agreement you would use to set whatever the terms are in terms of how you're paying them or their responsibilities, you would generally want to have a clause in there about the confidentiality, and that would basically put the NDA into that agreement with them. So then once you have that NDA with them, then you can talk with them about the various items that is not a public disclosure.
Okay, and Bryant, actually, you know what? We have a couple more, and we have about 5 minutes left. So if you don't mind, I'll throw a couple more at you.
Okay.
If you're going after advisors, you want to bring advisors into your company. Obviously, you got to talk about what you're doing. Again, the best way to do that is just through NDA if you're trying to keep your IP protected or your trade secret.
Yeah, so that's another contractual thing. So we have advisors at our company, for example, and there's a advisor agreement that we use. There are standard advisor agreements, which are sort of like contract agreements. So for example, if any of the attendees are using Clerky, for example, there's an advisor agreement on that system. And so that would include an NDA provision in that document. So that means once they sign that, then they're under NDA and you can share information. It's not public disclosure.
Okay, yeah, thank you. And then this is an interesting question. Let's say you're a company and you've licensed patent technology for your business or the core of your business. And then the patent during the term of that license, the patent actually expires. What is the impact on the original license agreement?
Yeah, that's a great question. So that has actually come up in a very famous case where someone had a license that lasted for like 20 years, but it lasted beyond the life of the patent. So you can't really collect license fees for a patent that's expired. So if you have a patent that's expired, you're not really able to get license fees for it because there's no rights there. If they could keep paying you, I guess you could keep collecting, but then they would have the right to get that money back. And you could try to structure it more as know-how and more product, so it includes something other than the patent, which is no longer a right after it's expired.
Okay, great. I appreciate that. I think that's it for today in terms of the number of questions. I think there's one more slide, if you could advance.
Yes.
Perfect. So listen, thank you guys for attending the webinar today. We appreciate it very much. If you are interested in no-cost one-on-one consulting with the SBDC, you can reach out to us on the information on this slide. We also get involved in patent and IP strategy, or we will refer you to one of our partners, for example, Bryant. You can fill that form out at sbdtech.com/contact. And if you have any other questions, please just email us on that form. Other than that, just want to thank you for spending your lunch hour with us. And we'll see you in a couple of weeks for our next webinar. Thank you so much. Next week? Yeah, next week.